Good morning, everybody. My name is Margaret Hinkle. Let me call this meeting to order and begin with a roll call of the commissioners in attendance. Commissioner Baker,
Good morning, President.
Commissioner Bluestone,
I'm here. Good morning.
Commissioner Calderon,
I'm here. Morning.
Commissioner Hall,
Good morning, President.
Commissioner Kazarosian,
Good morning, present.
Commissioner Luma.
Good morning, present.
All right, we are missing Commissioners Talley and Commissioner Crispin, but we do have a quorum. I will, at this point, take a vote on going into executive session in accordance with the following. First, under General Laws, Chapter 38, Section 21A1, to discuss a complaint against the commissioners under provisions of the open meeting law and regulations. And under Section 23 of that same statute and under Section 2905 of the Code of Massachusetts Regulations, and I should have said Section 940. Also under the same statute, that is Chapter 30A, Sections 21A1, to otherwise discuss the discipline or the dismissal of or complaints or charges brought against a public officer, employee, or individual under the same statute, but under Section 21A3 of that statute, to discuss strategy with respect to litigation, as an open meeting may have a detrimental effect on the litigating position of the public body. Under the same statute, but Section 21A5, to discuss the investigation of charges of criminal misconduct. Under Section 21A7 of Chapter 30A, combined with Chapter 6E, Section 8C2, and to the extent that they may be applicable, Chapter 6, Sections 168 and 178, to discuss the initiation of preliminary inquiries and initial staff review related to the same and regarding certain criminal offender record information, and under Section 21A7, also combined with Sections 22F and G, to discuss and to approve the minutes of a prior executive session. To just also address with regard to Matthew Hubbard versus Peace Officer Standards and Training Commission, case number 2579 CV 00432, filed in the Hampden County Superior Court, and James S. McCall versus Massachusetts Post Commission, a case filed in the Suffolk County Superior Court, and discussion of a complaint by William Castro against the commission under General Laws, Chapter 38, Section 23, a provision of the open meeting law, and 940 Code of Massachusetts Regulations, Section 2905, the Attorney General's regulations implementing the law, and also to address approval of the minutes of the executive session of August 14th, 2025. So I will,
Just let me lower this foolish thing that I have going on here.
I will now take a vote with regard, a vote of the commissioners with regard to going into executive session. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Hall,
Yes.
Commissioner Kazarosian,
Yes.
Commissioner Luma.
Yes.
And I also approve that. And members of the public, thank you very much for being in attendance. We will, after we address the executive session matters that I've just mentioned, we will come back into the public meeting. We anticipate that that should be at approximately 11 o'clock. Anything else we should take up before we go into executive session? So I think with that, we will leave the public meeting. Good morning, everyone. We have now resumed the public portion of the post meeting for today. The record should reflect that Commissioner Calderon is no longer present and that Commissioner Talley has joined us. So we do continue to have a quorum. And I think with that, Commissioners, I would entertain a motion for approval of the minutes of the August 14th, 2025 meeting. Is there such a motion?
I'll make that motion.
Thank you. Is there a second?
Second.
Thank you. Commissioner Baker?
Abstain from that vote.
Oh, correct. Yes, thank you. Commissioner Bluestone,
Yes.
Commissioner Hall,
Yes.
Commissioner Kesrosian,
Yes.
Commissioner Luma,
Yes.
and Commissioner Talley.
Yes.
I'm also a yes, so that's carried. Next, our Executive Director report. Over to you, please, Enrique.
Thank you, Madam Chair, and good morning, Commissioners. I will share my screen like I usually do and give you an overview of the activities of the last month. Can everybody see my screen? In presentation mode. Okay, so I want to start my remarks this morning with noting that since our last meeting, we counted 14 incidents in which a member of the law enforcement community or a member of the public experienced a critical incident. That is some kind of injury or accident involving law enforcement. 10 of those 14 instances involved an officer being injured, and 4 of those incidents were related to officer-involved shootings. One of those 4 involved the death of an individual, not an officer. A figure like this is a stark reminder of the hazards of the profession. By our count, this was a particularly busy and unfortunate month for law enforcement in the Commonwealth, and I just wanted to note that. As part of my report this morning, I will limit it to 2 items, as I will allow time for our Chief Financial Officer, Eric Ravello-Pradas, to provide you with a year-end financial update and a fiscal year 26 spending plan overview. As a reminder to those in attendance, the public and the press who want to reach us, they can do so always by using the resources on the screen. And we very much accept and appreciate written comment at any time. So, as I mentioned, I will provide an update on the 2 topics on the screen. These will include an overview of a particular aspect of the disciplinary records project, which is some additional detail that we will be releasing as part of our next release. This release will also be on an ongoing basis. I will also update you on some of the recent outreach and speaking engagements that some of us at Post have been a part of. And as previously mentioned, Eric will come back with a fiscal year 25 overview because the fiscal year end, the accounts payable period ended recently, and now we have final numbers. Okay, so as mentioned, I want to focus on an aspect of the disciplinary records project. That is the fact that many of the records that have been submitted to Post and eventually gotten published come with different levels of detail. This is true for records across different agencies, but it's also true for at times for records within agencies. We get questions and I get asked, what does Post do about these kinds of differences? It is fair to say that a big part of those differences stem from the reality that there are multiple individuals interacting with our portal, because there's, of course, many agencies, and they're all required to provide information that will eventually be public, and it has not been our practice to significantly modify those details that are entered by those agencies. However, as I mentioned, we get asked, what do we do about this? to ensure that these records do not have such different levels of details. And we appreciate these kinds of comments from a fairness perspective, and we frankly agree with the notion that we don't want big differences between the level of detail among all these records. So our approach is that we will add detail to those records that merit so, as opposed to eliminating detail for the sake of uniformity on previously published records. But just to answer the question directly, the short answer is that we do quite a bit when it comes to management of these records, and with the caveat that we still, of course, rely on the agencies to enter a lot of the information. We have embedded certain workflows to try to minimize differences in the level of detail, and will soon be deploying what I believe will be a new field that will greatly help towards the goal of making some of these records more uniform across agencies. A couple of those workflows I reference is the fact that we have a small number of categories and subcategories of misconduct. This was a decision we made early on within our portal, so that there are some certain categories that could be later reported on. And we also, within the last few months, we have taken steps to limit the number of characters that agencies can enter in certain fields, like the allegation details or the agency comments. Many of those that will go a long way towards that uniformity, but I think what I will describe shortly will also enhance that important goal. I do want to mention that since 2023, agencies have been submitting IA reports in different formats, and that is really the source of what I will term what we will review to add those levels of details. So my remarks really are reference to records after 2023, not historical disciplinary records. So I want to here briefly summarize the review process that happens at post. When it comes to disciplinary records, we review and read every report that is submitted, and where appropriate, we will redact information that we believe must be redacted before we publish those records. As you can imagine, this is a very involved process, takes quite a bit of staff time. First, our intake team reviews the internal affairs report and ensures that the allegation details match the findings of the report. This is an important quality assurance process. As commissioners know, we do not publish unsustained or unfounded allegations, and wouldn't want errors to fall to cracks that way. As I have reported in the past, the intake team also coordinates with agencies the submission timeframes that are spelled out in the regulations. In some cases, there may be 3 different submissions for one particular incident. In other words, an initial report is the first instance, the result of the investigation is the second, and third, maybe the discipline that was imparted. The intake team also responds to requests for modifications and will look to evidence submitted and the details of the report to modify the wording of those allegations. Next, a standards supervisor, either the director or the deputy director, reviews every record, and where applicable may modify or ask the intake team to modify language, or ask the agency to provide additional details for the general purpose of standardization and clarity. The standard supervisor is also effectively monitoring those incidents to ascertain whether post may want to follow up and or recommend to the commission whether to open a preliminary inquiry. After that second level of review, within the standards team, our legal team will review and apply any redactions if necessary. And on the cases where post imparts discipline, the enforcement council within the division of standards will write up the post discipline. Throughout this process, the information technology team or our IT team supports and facilitates the data management. For example, it's ensuring that we have the original language and the redacted language, as well as ultimately publishing the report. I should mention here that the IT team has been working on making more reports available in the near future, which is why the reports here in the slide is in the plural. I will come back to the commission at a future meeting, hopefully very soon, to update you on additional reports that will soon be available in our website. Now, in the recent past, we have been working on writing complaint summaries. The idea behind this new field is to provide a fair and succinct summary of the actual events or incidents, or the incident as it happened after they have been investigated and the disposition has been rendered. Too many times, the allegation details that are ultimately published only include details of the type of policy or rule violation, or in other words, is missing the actual description of the event, incident, or the complaint. The original idea was to capture all of that in a field that's called narrative, but we do not publish that field because too many times that includes what later are proven to be unsustained or unfounded allegations. The upshot of all of this is that we have been working on publishing additional information based on a review of all of these records. And again, those summaries will be written by post staff, and they will be based on details submitted by the agencies. These summaries will not be available to for historical disciplinary records, as I mentioned, given that we did not capture the internal affair reports of all of those early submissions. But we will be releasing those complaint summaries as they become available as part of our ongoing review, or in other words, on a rolling basis. And we're scheduled to do that in the next release, which should be very short. With that, let me highlight 3 presentations or speaking engagements that 2 of those instances happened very recently, and 1 other is upcoming. At these 3 events, somebody from Post presented or has been part of a panel discussing police reform or Post activities. On September 10, Chair Hinkle returned to her alma mater, Boston College, and joined a panel discussion on the state and local response to the current federal government policing agenda. The work that Post does was featured as an important component of such local responses. This in-person event also had a remote participation, and we understand that was very well attended. Secondly, I want to mention that just last week at the annual Municipal Police Chiefs Association conference that happens in Norwood, our own Director of Standards, Matt Landry, presented important updates on the internal affairs process that Post expects chiefs to follow. I should note we are not sponsors of that conference, but however, the association allows our staff to have a table that people can approach in between sessions, just like they do for sponsoring organizations. This presence does facilitate important interactions between our staff and chiefs and deputy chiefs. These interactions facilitates important interactions between chiefs and our staff, and that was also very important. Throughout those interactions, we did hear that Mr. Landry's session was very well received. They found it very helpful, and it was really good to hear. It could be that he also mentioned a number of things that we're working on that will make the submission of information a little bit easier for chiefs, and again, that is always appreciated. So, and finally, in 1 week from today exactly, I will be part of a panel providing an update on the Post activities to the Mass Municipal Association. They have, the MMA has a series of webinars. They have a large membership, and they are typically very well attended. We presented to them in the past, but given the large group, we appreciate every time they have us back. And we also appreciate that there's a lot of interest from municipal officials relative, and of course the organizers relative to the activities that Post does. I will be joined by Eric Astupenas, who is the legal counsel from the Mass Chiefs, and the chief from Norwood, Chief Christopher Patton, as the panelists. As of yesterday, there were 275 individuals registered for the webinar, and organizers tell us that the audience typically will likely approach 300 members, which is typically a really good turnout for them as well. In addition to this, back in July, I met with the major city chiefs, and in August, we met with the sheriffs and the Sheriff's Association. We typically meet with the MPTC on a variety of topics. We most recently met with them on the topic of in-service training and officer physical fitness standards. With that, let me pause there and see if commissioners have any questions or comments before I turn it over to Eric. Seeing none, Madam Chair, that concludes my report.
Thank you, Enrique, and those who have worked with you. And I think with that, we move on to Eric and the financial report.
Eric, we cannot hear you. You're not muted, but it doesn't look like we can hear you.
All right, just a moment.
Okay, is that better?
Yes.
All right, sorry about that. Okay, just want to make sure folks can see the screen there. All right, excellent. Thank you. Okay. All right, all I want to do is just cover a couple topics here, two main topics, just that closing out of the last fiscal year, which was FY25, which ended June 30th. And then I just want to get into what our plans are for spending for the new fiscal year, the one that we're in right now, which is FY26. So back to FY25. In July, we had estimated that final spending would range anywhere between just over 8 million to about 8.1 million, $8.1 million. But as you can see here, we came in slightly under that estimate at 7.98 million. But this represents about 91% of the funding that was budgeted to us in FY25. So post reversion back to the general fund, which you see there in green, was about $765,000. And the vast majority of this amount, about 80% of it, does stem from payroll savings. Okay. Now, just before I get into the FY26 spending plan, I just wanted to give a brief recap of how we went from what we were requesting, which was back in October of 2024, to what we ultimately received, which was in July of 2025. So it's certainly a long period. So some of you may recall, we had requested close to 9.5 million for our FY26 budget. And when we presented that to A&F, ultimately in January, when the governor filed her budget, the appropriation came back to us 6% less. So it's just about $571,000 was reduced from that. Now, when we went on the road and we went to the Joint Ways and Means hearing, we did say that we still wanted to get, somewhere between this low number and what we were requesting, but we would be able to manage it. It was a big hit, but we would still be able to manage it with payroll savings and so forth. So the legislature concurred with the governor's number, and they also had given us the 8.9 million that you see there, the reduced number. But what happened was a little bit of a surprise, is that the conference committee then released the budget, the final budget, but they had also tacked on an additional 1% reduction. And that we weren't expecting that, and that kind of hit us there. So that's what we were really kind of concerned about. So we know, we still believe we can manage this. And there's a lot of detail that I have provided to you in the memo, which was included in your packets. I won't get into too many of those details here, but we do believe we can manage it. But we would want to emphasize that we do believe it will be tight this fiscal year. Now, getting on to what's in the spending plan. The F&A team recently met with Commissioner Loomer and the executive director to review spending plans for FY26. And those plans were submitted to A&F last month, and we are still awaiting their feedback, which we should be getting, I believe it's the first week of October. Now, just looking at the table in front of you there, on the left, obviously, those are the categories of spending. To the right, the blue column that you see there, that's the budget that was passed and signed by the governor. The next column over, which says FY26 post BGTS, basically that's just those net zero allocations that we make to and from certain categories so that we can sort of right size the spending. Because remember, the budget is created back in October, it's filed in January, and then you have 6 months that pass before anything gets finalized. So a lot of times you have to do these technical edits as well as other adjustments you need to make. And that's what you see there in that middle column. And then, of course, the column all the way to the right is our final spending plan for FY26. I'm not going to go into each and every one of these small, but I do want to highlight a couple of them. If you go down about 3 rows where you see contract employees, which the code is CC, you can see there that we're adding about $26,000 to that particular category. That's because we had to pay for an IT contractor this fiscal year that was serving as a backup to our business analyst who had left a few months ago. So we had to do that so that we wouldn't get behind in any of our IT projects. Also, we wanted to make sure we could sustain at least 3 interns this fiscal year, and that's why you see that final number there of 96,000. So that's for 3 interns, and then, of course, the IT contractor. A couple more down where you see office supplies, postage, and subscriptions. We are taking out about almost $40,000 there that we're not going to need. That's from the parking savings. So as you may recall, a while ago, we had decided no longer to provide parking for the entire staff. So it is now limited parking. So that's what that savings is that you see there. We're able to allocate that somewhere else. And then a couple more down where you see consultants, legal services, HH. You could see a good chunk is taken out there from what we originally budgeted, about $64,000. That's, again, we keep reducing our reliance on outside or third-party consultants. We're just not using them as much because we have the in-house staff, especially with the legal division, to take care of a lot of those needs. So that's why you're going to continue to see some drop there, or some further reductions there. And then finally on the bottom where you see information technology, we're adding a little bit of money in there, about $45,000. That's to pay off the balance of that one-time projects for XFACT that was basically allowing us to have access to deciduous data and information, and as well as we needed to top off some of the Salesforce licenses and Tableau working hours. One final note I just want to make here is that back on August 14th, the governor filed her final deficiency supplemental budget. That is the final budget for FY25. That's to close out the fiscal year, which doesn't officially close until Halloween. So what we did is we had asked permission if we could use about $74,000 in unspent FY25 money, if we could use that in FY26, sort of as a supplement. And right now, the legislature has not taken this piece of legislation up, so we don't know if we're going to get those access to those funds. We are hoping to. If we do, that is going to offset some of the costs that I had highlighted earlier. For example, the one-time deciduous cost, paying for the security door. So that actually will help us a lot if we're able to get that PAC or prior appropriation continued. We'll also be able to hire some more interns as well, so we could get more on a level that we were at last year, as opposed to only having about 3. All right, some of the higher areas of spending. No surprise, payroll is always the big one, but 6.6 million. This is for hiring an additional 6 positions, new positions, and we are hoping to get it to about 60 employees by the end of FY26, so June 30th. Now, one of the things we're doing to sort of manage our constrained funding this year is we are going to purposefully delay the onboarding of about 7 open positions that we have right now, and that'll get us just over $350,000 in savings. Again, we're basically, instead of hiring for July 1st or September 1st, we're going to push a few of these positions off to maybe January, and then push another few off to perhaps March or April, and this way we can get a little bit of savings to close out the fiscal year, so that we can actually reconcile by June 30th. Again, these are sort of the things that agencies typically have to do when money is a little bit tight, and so we're going to do that. And we'll have more and more information as the months go on. Hopefully by Q2, by December, we should have a pretty good indication of exactly how many employees we'll be able to hire and when we can hire them and so forth. One of the other, 2 of the other things I wanted to mention is, again, information technology is another one of our biggest hits for the budget. It's virtually all maintenance though now. There's very, very little development costs that we're doing. And 50% of those maintenance costs are all for our Salesforce system. And then, of course, the third largest piece is our rent down at 84 State Street. And then finally, just wanted to show you the org chart. This is a proposed org chart for FY26. Shows you where we are right now in the black font there. You can see we have 49 positions that are currently filled. The green shows you the ones that we currently have open. And then the red ones at the bottom, those are the 6 proposed positions for FY26. And of course, all of those plus one of the green positions, we are purposefully delaying in order to assume some savings. As I had mentioned before, more details are included in your packets in the memo, but that pretty much wraps it up here. Thank you, Madam Chair.
Thank you, Eric, and those who have worked with you. And thanks also to our treasurer, Charlene, with regard to the work that she's been doing with you. And we appreciate all the information that you provided to us. I don't think there are any questions, although I can't see the entire screen. Any commissioners have any questions? If not, we'll move on to the legal update, please.
Thank you, Madam Chair. I will turn the floor over to Counsel Annie Lee.
Thank you, Randy, and good afternoon, Madam Chair and Commissioners. Today, we will be presenting 3 agency certification standards for your consideration. The first standard relates to officer response procedures. I will be presenting a second round of revisions for your review. Pending any final questions or feedback that you may have, I anticipate asking for your preliminary approval of this standard. The second standard today relates to criminal investigation procedures. I will be presenting a first round of revisions. I will not be asking for your preliminary approval, just looking for further feedback and reactions you may have. And finally, the third standard of the day relates to detainee transportation. George Boateng, one of our legal fellows, will be presenting this standard. This is the first time that detainee transportation will come before you, so George is looking for your initial reactions and feedback. And so to start us off today with officer response procedures, a copy of this standard is available in your packet, starting at page 69. This standard was last before the Commission in August when a first round of revisions was presented for the Commission's consideration. Following that August meeting, those revisions were then presented to the MPTC. The MPTC during its meeting indicated it was largely satisfied, but provided some additional feedback in a couple of spots, which will be the topic of my presentation. Because that feedback was fairly discrete and resulted in only a couple small revisions, those proposed revisions were presented to the MPTC earlier this month. And so those proposed revisions cover the definition of developmentally and age-appropriate, trauma-informed, racially equitable, and culturally relevant tactics and techniques and interactions with vulnerable person. So to that first revision, which is to the definition, MPTC, during its August 2025 meeting, they raised concerns about the use of the phrase tactics and techniques, even though that's a phrase that appears in both the post-commission's enabling statute as well as guidance post previously issued. MPTC stated that in their experience as law enforcement, tactics and techniques has a specific meaning that implies something more discrete and more concrete than the type of broader critical thinking framework that we call for within this definition. And so to try to address that concern, here we're proposing revising tactics and techniques to approaches. The next and final two revisions to officer response procedures relates to interactions with vulnerable persons. The first of these two revisions is about utilizing developmentally and age-appropriate, trauma-informed, racially equitable, and culturally relevant approaches. The MPTC, again during its August meeting, questioned whether there might be situations where it's not feasible to utilize these approaches when interacting with a vulnerable person, such as when a vulnerable person poses an immediate threat to themselves or to others. And so to account for this possibility, what we've done here is we've suggested this could be revised and more accurately qualified so that officers are directed to employ developmentally and age-appropriate, trauma-informed, racially equitable, and culturally relevant approaches when time and circumstances reasonably permit. And this phrase, when time and circumstances reasonably permit, is something that we use frequently throughout this standard as well as other standards in order to provide officers the flexibility to respond to the kind of threats that require immediate attention. And so the second of these two revisions is about making connections to support services for consistency with a similar provision that encourages officers to utilize appropriate alternatives to arrest, incarceration, and hospitalization. Here we're proposing revising this directive so that officers are encouraged rather than mandated to make efforts to connect people in need to appropriate support services. And so this gives officers the flexibilities to sort of respond if there is an emergency that sort of takes them away from a situation. And this can be particularly beneficial in the smaller departments where they just might not have the staff to adequately sort of spend time with the current situation, but also respond to one that's coming in at the moment. And so that concludes the revisions to this specific standard. And as I previously mentioned, the MPTC reviewed these limited revisions earlier this month during their public meeting. They indicated that they were satisfied and had no further feedback. So at this time, if the commission is amenable, of course, happy to answer any questions. I'm asking that the commission provide its preliminary approval of the draft officer response procedure standard as discussed and presented today.
Thank you. Attorney Lee, let me ask my fellow commissioners whether there are any questions or comments on her presentation. If not, let me call for a vote. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Hall,
Yes.
Commissioner Kajirosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley,
Yes.
and I'm also a yes. So that's unanimously carried by the commissioners in attendance.
Thank you very much. All right, and so as I mentioned, we have three standards today. So I'll next move on to our second standard, which is criminal investigation procedures. A copy of that standard is available in your packet at page 81. And so criminal investigation procedures was last before the commission in April when it was presented for your initial feedback and reactions. Following the commission's April meeting, we sought the feedback of the MPTC and its staff, and they provided that feedback during their July meeting. What is before you today is the first round of revisions, and those relate to the elements that are in yellow on your slide, which are reporting criminal activity, youth, and communications. But with that, we also have two revisions to the definition section. And so the first revision comes to the definition of responsible adult. The initial draft standard included a definition for the term responsible adult, which we defined as an individual 18 or older with authority to make decisions on behalf of the youth. And so this definition can be quite broad, and it can apply also in the juvenile operations context. But in this specific criminal investigation procedure standard, the phrase appears in a very specific context. And so it appears in provisions that relate to the non-custodial interview and custodial interrogation of youth. And in those provisions, we direct officers to allow a youth responsible adult the opportunity to be present for the non-custodial interview or custodial interrogation based on the interested adult rule as articulated by the Supreme Judicial Court in 1983 in Commonwealth v. a Juvenile. And here, we propose revising responsible adult to interested adult with a more narrow and tailored definition. And we do that for two reasons here. And so the first reason is that the SJC in that 1983 case, they use the term interested adult. And so it's known as the interested adult rule in the context of juvenile interrogations. And so, and which leads to the second reason we would propose revising this to interested adult, which is that we're using this concept of an adult who can help a juvenile understand their rights and how to proceed in a criminal investigation, because it's a very specific context. We're not talking about sort of broader juvenile welfare or juvenile operations as we are in a separate standard. And so our hope here is that by replacing responsible adult with the broader definition of responsible adult with a more tailored and specific definition of interested adult, which I'll note for you here, we're proposing defining as an individual 18 or older with whom a youth can consult with for the purposes of determining whether to waive the youth's Miranda rights. We're hoping that the terminology in our standard will more closely align with the context in which this terms appear, both law enforcement and also potentially legally, if this does result in some sort of prosecution. And so the second revision to definitions comes to family. So we initially sought to, for the purposes of a conflict of interest provision, define who's part of an officer's family by listing different individuals who should be considered part of an officer's family. And rather than listing those individuals, because I think we can think of, a number of different sort of folks who officers know who may be considered family, and then there is also sort of considerations of family by adoption, by marriage, et cetera. Here, rather than sort of being so specific, we're proposing defining who is part of an officer's family by describing 3 categories of individuals. And those individuals are first the members of an officer's family, and that's generally conceived of as immediate family. The second is members of the officer's family who reside in the officer's household. So that may extend to folks who are not necessarily part of the immediate family, but who reside within the same household. And third is relatives within the third degree of relationship. And so that casts a broader net. And so we propose defining family in this manner because it is consistent with the Code of Judicial Conduct, which prohibits judges from engaging in certain behaviors and activities and requires them to make sort of certain disclosures or in some cases disqualify themselves in order to avoid the appearance and or actual conflict of interest in matters that involve members of a judge's family. And where here the conflict of interest provision is aimed at avoiding the appearance of or actual conflicts of interest, we thought it was appropriate to map that definition on. All right. So the next revision before you today concerns agency and officer conduct. And so, as you'll recall, in the initial draft of the standard, we sought to prevent agencies and officers from inadvertently deterring or retaliating against individuals who seek to report or have reported criminal activity by while preserving law enforcement's ability to diligently investigate reports of criminal activity. And so the way that we tried to do that was to prohibit certain behaviors like requiring reports to be made under oath or penalty of perjury, and the running of criminal background checks, warrant checks, and immigration checks. We sought to prohibit those behaviors when those behaviors are prompted solely by the fact that someone is trying to report or has reported criminal activity. What we heard from MPTC staff, though, is that the balance might not be quite right, and that officers would be prevented from doing their due diligence and some basic due diligence to investigate reported criminal activity. And so here, we're proposed to better strike the right balance is emphasizing the intent aspect of this prohibition. Essentially, the behaviors that we're worried about, those behaviors are prohibited if they're undertaken in order to discourage, intimidate, or retaliate against someone because they seek to report or have reported criminal activity. And so trying to make it more clear when that behavior is not permissible. And then the next two revisions to this standard relate to youths and specifically procedures and safeguards during non-custodial interviews and custodial interrogations of youths. The first pertains to procedures officers should follow to ensure that youths understand their rights before participating in a non-custodial interview or custodial interrogation. And so previously, the standard directed officers to obtain a youth's clear and unambiguous understanding of their rights when seeking to conduct an interview or interrogation. However, obtaining such an understanding may not always be possible based on the youth's age, mental ability, education level, prior experience with law enforcement, or other factors. And so to account for this potential, we don't want to direct officers to do something they may not be able to obtain. Instead of doing that, we've revised this directive so that officers may only commence a non-custodial interview or a custodial interrogation of a youth after obtaining the youth's clear and unambiguous understanding of the youth's right. So we're not necessarily changing what the procedure is, but it's more so changing the obligation on the officer. The second revision in this topic pertains to deception in custodial interrogations. So as initially presented to you, the standard sought to outright prohibit officers from threatening, intimidating, and coercing youth during custodial interrogations. And this was based on research that shows that youths have an increased susceptibility to threats, intimidation, and coercion, and also data from wrongful convictions showing there are quite a number of wrongful convictions of youths that are obtained in whole or in part because of threats, intimidation, and coercion. And some of those wrongful convictions have occurred in the Commonwealth. And so to that end, we specifically sought to prohibit officers from restraining a youth when they're not a threat to themselves or others, using, threatening to use, or causing a youth to perceive that an officer would use force, threatening the youth, using profanity or derogatory language, threatening or humiliating speech, and using deception. The MPTC, however, raised concerns about an outright prohibition on attempting to coerce a youth, and in particular, the prohibition against using deception when interrogating a youth. The MPTC acknowledged that while there are extreme cases in which deception is inappropriately used, they suggested there are times when an officer wants to coerce a youth into cooperating with a criminal investigation, and one of the ways that they do that is by deceiving a youth. And so, in their view, deception is a valid investigatory tool. To the extent that Post and others are concerned about those extreme cases of deception, the MPTC suggested that the SJC has already articulated sufficient safeguards that should protect against future wrongful convictions that come about through inappropriate tactics during youth interrogations. And so what is before you is just one suggestion of how we can try to strike the appropriate balance here. So the appropriate balance, of course, between protecting youth and enabling the lawful investigation of criminal activity. And so the revision here before you suggests, adding in similar kind of intent language that certain behaviors are prohibited when they are intended to threaten, intimidate, or unlawfully coerce a youth. I'll note for you here that the unlawfully is an addition to what was previously drafted, and also specifying here that deception is prohibited when it is excessive or unreasonable, rather than an outright prohibition. So really guarding against those extreme cases. And also in this section, separate from this point of discussion with MPTC about deception and coercion, The revisions before you also propose adding in provisions that prohibit interrogations that are unreasonable in length without reasonably frequent and substantial breaks, and also clarifying that threats can include suggesting unknown or unrealistic benefits or negative consequences if the youth does not confess in a criminal investigation. The last revision to this standard relates to communications. These revisions are really meant to clarify what we're asking agencies to do in a communication sub-policy or provision. And sort of that clarification is that we're asking agencies to address within such a sub-policy or provision what information about a criminal investigation will or will not be communicated, if it will be communicated, when it will be communicated, and also how that may differ with different parties, including individuals who report criminal activity, as well as the public, whether that's through the agency's own channels or with the media. And so with that, I'll take down these slides. I'm happy to answer any questions about this standard.
Yeah, I have a few questions.
Please.
As the MPTC approved, I know you said you've been back and forth with them. Have they approved your final revisions? In some of these things, it seems like you're right and beyond what the SJC has already set it as the standard.
So these first round of revisions have been discussed with and have been really formulated with MPTC staff. It has not gone before the MPTC itself as a public body yet. My hope is that it'll go before the MPTC during their next public meeting. And pending any remaining feedback, I would come before the commission either for more updates or for preliminary. But these are the first round of revisions with MPTC staff. We understand that this still needs to go back before the MPTC, which is why we're not asking for a vote at this time.
Okay. And back to can you just give me some more clarification on that? Go back to the slide with the conflict of interest. Is that a conflict of interest for officers, or are we looking to define who's a family member of a juvenile?
This is for officers. So this is for a conflict of interest provision that would apply for criminal investigation. So if a report of criminal activity is made that involves a member of an officer's family, the conflict of interest provision would prevent that officer from participating for conducting.
Got you. Understood. And my final question is on your last part. So are you telling me that we're now going to decide administratively from post how a department releases an ongoing investigation? If there's an investigation ongoing, we're going to put a policy, regardless of where that investigation is, that it's going to be released?
We haven't specified that. What we're trying to do here is to sort of direct agencies. You set for yourself in your policy what you will communicate and when. So an agency could decide that where a criminal investigation is ongoing, it's categorically not going to communicate anything. It could also decide alternatively, right? Maybe there are exceptions where it's a criminal investigation concerning a matter of, public interest that, they'll say an investigation is ongoing. It could stop at that. It could go beyond that, but we really leave it to agencies to determine what they will communicate and when and with who.
Okay. All right. Good. Thank you for the clarification, because that's exactly the way it works. There's some parts of a case you can discuss and there's other parts you can't. And sometimes there's nothing you can discuss. But I just would not want to see it one blanket scenario, because every scenario is different and every scenario is different time factors. But thank you for that clarification. I'll end all my questions now. Thank you.
Thank you, Commissioner Baker.
And I don't think I see any other commissioners' hands in the air. Thank you very much, Attorney Lee, for that presentation.
Thank you, Madam Chair. And so our third standard today concerns detainee transportation, and I will turn it over to our one of our legal fellows, George Boateng, to present this standard.
Good afternoon, Commissioners. My name is George Boateng, and I'm a legal fellow of the Commission. As Annie mentioned, my portion of today's presentation will be on detainee transportation standard. In drafting this standard, we consulted with various resources from some of the most influential professional association for police leaders like the IACP, and we also reviewed Baltimore's police department's persons in police custody, which the DOJ helped write in response to the public attention to the death of Freddie Gray. This presentation will provide a high-level overview of the key principles of what the standard strives for. It will touch upon officer conduct, transport vehicles, searches, restraints, supervision, transportation considerations, safety, the transfer of detainee in custody, and also officer training. Can we move to the next slide, please? So beginning with the key principles, this standard is consistent with Mass General Laws Chapter 6E's emphasis on improving interactions with the public and ensuring bias-free policing. In a human-first and centered approach, an agency's detainee transportation should emphasize the sanctity of life and bodily integrity, and a dignified and respectful treatment of all detainees. Next slide. Thank you. And next we have officers' conduct. The underlying rationale is consistent with the notion that humane treatment of detainees by encouraging officers to consider the physical safety, the mental and emotional vulnerabilities, and the potential embarrassment of detainees create a dynamic of respect and integrity. In efforts to give a detainee an agency that does contribute to an officer's safety, officers should explain to a detainee what the officer is doing, where the detainee is being transported to, and the next steps. And next we have the transport vehicles. And this is before even an officer even interact with the detainee. And this is important because research has shown that a proactiveness in vehicle maintenance can ensure public safety, signal professionalism, and also instill public confidence. Agencies should address the types of cars that may be used as a transport vehicles, the modification necessary, and the routine inspection and maintenance required to keep the vehicle operable. Next slide. Yes, thank you. Next, we have searches. And in continuation of the last slide, I will first focus on searching a transport vehicle. To protect the detainee and the officer from any potential dangers or harm, and to ensure that certain items are not misattributed to a detainee, procedures should be in place to ensure that before and after placing a detainee in a transport vehicle, that the vehicle is free of weapons, contrabands, or any evidentiary items. Next, we have searching a detainee. A detainee must always be searched before being placed in a transport vehicle, regardless of any previous searches. Consistent with the key principles of improving policing, treating detainees humanely, and ensuring the safety of officers, a search should be the least intrusive but most effective manner necessary to ensure safety of both the officer and the detainee without demeaning the detainee. Next slide. And next we have restraint. And this is before a transport vehicle is in motion. And this provision was drafted with particular attention to the IACP policies and the implementation of Baltimore's person in police custody after the death of Freddie Gray. Consideration to the personhood of the detainee is vital whenever restraints are used. And this consideration is in alignment with respect to an officer's safety. A detainee must be restrained in the least intrusive and most effective manner without intentionally causing a risk of injury, actual injury, or undue pain or discomfort to the detainee. Securing a detainee within a transport vehicle should never be done without the appropriate devices, and detainees should never be affixed to any part of the transport vehicle. Next, we have supervision and the surveillance of detainees. Detainee supervision is important before a detainee is placed in the vehicle and during the course of the transportation. The purpose of this provision is to promote transparency and accountability for both the officers and the detainees. Agencies should set policies on keeping detainees under constant supervision throughout the time they are in custody. And this should be either through direct observation or through live audio and/or video transmission. If the agency's transport vehicle has camera systems to monitor detainees, then officers must activate such a system for the duration of the transportation. And if the agency does not have such equipment, then officers must activate their body-worn cameras or any in-car audio or video recording system. And now we have certain certifications or certain various considerations during the course of transporting a detainee. So now we are in the car, we are in the transport vehicle. The Commonwealth has passed laws in consideration of the safety and comfort of detainees in regard to their gender identity when being transported. And so agencies' written policies should include provisions requiring a detainee to be transported by at least one officer of the same gender, and also not in the same vehicle with a detainee of a different gender identity. In drafting this, we understand that sometimes time and circumstances might dictate otherwise, and this is something that we are very clear and cognizant of. An agency's policy should also direct officers to transport a detainee without unnecessary delays, while also addressing the circumstances when an officer may need to conduct other law enforcement activities while transporting a detainee. Lastly, agencies should have the directive on transporting youth detainees, as our studies have shown that the brains of youth are not fully developed, which enables them to make more impulsive decisions, and they're more susceptible to peer pressure. And also they are sometimes less able to foresee the consequences of their actions in comparison to adults. And now we'll move on to the transfer of detainees. Oh, I'm sorry, yes. Now we'll focus more on the safety, some of the safety procedures during the transfer of, during the transportation of detainees. And so this policy requires the agencies to include a sub-policy or provision and to include a sub-policy or provision that direct officers to operate the vehicle in a manner that aims to preserve the safety and security of all passengers. And also we want these provisions to direct officers to obey all traffic regulations except during exigent circumstances. And with our research and our discussions on rough rides, we want to ensure that these policies or these provisions require officers to not operate the vehicle in a manner intended to create discomfort to the detainee, which is not limited to just unnecessary speeding, but also braking and making sharp U-turns, actions that are meant to make the ride as uncomfortable for the detainee as possible. And also we want officers to, of course, to provide an appropriate and timely medical responses to a detainee who requests for it, or due to a response to the scene conditions of the detainee. Next, we have the transfer of detainee in custody. And this is during the transportation of the detainee. The safety of detainees, officers, and the general public are directly tied with each other. So the certification requires agencies to include provisions in their written policies that direct officers to operate the vehicle in a manner that aims to preserve operate the vehicle in a manner that aims to preserve the safety and security of all passengers, but also while communicating with parties or communicating with agencies that will be receiving the detainee, we want the officers to communicate information regarding the detainee's known or suspected physical condition or medical health. And also, the officer should convey if the detainee has made any medical request or has made any request for medical attention. And next we have training, and this is very short and simple. We just want in the provisions, agencies should ensure that trainings are in accordance with all applicable training requirements. And once again, thank you, commissioners. This concludes the end of my presentation, and I'm happy to answer any questions or provide any clarifications.
Thank you very much, Attorney Boateng. I don't think I see any commissioners' hands in the air, but we greatly appreciate the material that you provided to us. Thank you.
Thank you very much.
And I think with that, commissioners, there are no matters which are not anticipated by me in connection with this meeting. So I would at this time entertain a motion to adjourn. Is there such a motion?
So moved.
Is there a second?
Second.
And I don't think we have to take a vote on that. Thanks very much to all the staff who have provided the material that we've worked with today. Thanks to all the commissioners for their careful attention to the matters that we've addressed. And I think with that, goodbye for now. Thank you.
Thank you.